In 1995, at age 35, Mark Martin was installed as the youngest justice in the history of the Supreme Court of North Carolina, a theme that you'll hear throughout his bio. He served as an associate justice beginning in 1999 and was appointed as Chief Justice in 2014. Martin was installed in 1994 as the youngest judge in the history of the North Carolina Court of Appeals, and in 1992 as the youngest Superior Court judge since the colonial era. He's served on the adjunct faculties at Duke, North Carolina Central, and the University of North Carolina Law Schools, and has served previously as legal counsel to the governor, as associate at the McNair Law Firm, and law clerk to United States District Judge Clyde H. Hamilton. Chief Justice Martin has previously held many national and state leadership roles. Chief Justice of the United States Supreme Court, John Roberts, appointed Martin as a member of the Committee on Federal State Jurisdiction of the Judicial Conference of the United States. He's also served as a member of the Board of Directors of the Conference of Chief Justices. Martin is a former chair of the Appellate Judges Education Institute Board of Directors. And at the state level, Martin chaired the Chief Justice's Commission on Professionalism, the North Carolina Equal Access to Justice Commission, and the Chief Justice's Commission on the Future of the North Carolina Business Court. Specific to today, Chief Justice Martin is deeply committed to advancing the rule of law and improving the administration of justice, something that those of us who have worked with him know well. Martin convened the North Carolina Commission on the Administration of Law and Justice in 2015, and an important objective was improving the operation of our criminal justice system. The Commission recommended, and the General Assembly enacted, landmark legislation that ended North Carolina's practice of automatically prosecuting 16 and 17-year-old juvenile offenders as adults. Chief Justice Martin is a dedicated public servant. He's dedicated to the rule of law and to first principles, and he is dedicated to getting the law right, something that I respect deeply about him. And so, without any further delay, I'd like to introduce our speaker, Chief Justice Mark Martin.
Well, good afternoon. I want to take a quick frolic and detour and just thank Mike for his great work on this topic. I'd like to thank the Cato Institute for partnering with the John Locke Foundation here in North Carolina, Christopher Hanford and Becky Gray, and so many that are trying to make sure that our criminal law body of laws are understandable, clear, and appropriate for this state. I was listening to Mike's remarks about how we were faring there. I don't like 43 out of 52, so we're going to have to work on that a little bit. But let's take a moment and just thank Cato and John Locke Foundation for leading us in this effort. So the theme of my remarks is really how can we protect the public on the one hand, and on the other hand, secure individual liberty for future generations. But before we go there, it's always nice to kind of enjoy a few editorial cartoons. So I know we've seen this where the latest Hollywood actor has a drug issue. We never hear about, we never see handcuffs, we never see any criminal justice repercussions for that. And so I know we try very hard in the system to bring about equal justice, but I think particularly in the drug area we have to be cognizant at times about the more often reality. So here we go. Remind me again who's the prisoner here. And as I'll talk about in a minute, our criminal justice system is a very large enterprise, and so we have to be smart. We have to get it right. Now this one may take a little bit of explanation. Probably everybody in the room knows that we have an honest services provision in federal law. And in addition to our bribery rules and really a lot of the other statutes at the federal level that are designed to keep our public servants honest. And so here you have the Supreme Court decision where the justice says, well, we threw out the parts of the law making it a crime to deprive the public of honest services when we realized it applied to most of you. So I hope everyone gets that humor there. So this one comes a little bit close to home. I thought as a Chief Justice I'd be exempt from editorial cartoons. How I did not realize that as we went through the Raise the Age issue that yes, I too would be on the editorial page. I will tell you the duck came in handy. It's pretty good to kind of use how tall is someone as a pretty good gauge, right? But so that brings back good memories where everybody knows we had 107 out of 120 House members that voted for Raise the Age. It was a good day in North Carolina to see that change take place in our law. Well, I know I'm not sharing news now that everybody has not heard before, but we know at the federal level we've had a lot of things taking place on in a bipartisan manner, and I think a lot of people are wondering what's going to happen next in terms of criminal justice reform. So I am going to talk a lot about our set of criminal laws, but also a few comments about criminal justice reform itself. One theme I want to leave with everyone is the importance of engagement on this topic. And I am delighted that Cato and John Locke are both engaged on this topic because there are a myriad of aspects, a myriad of different perspectives on this issue. And there are many who would like to take some pretty broad steps in this area. So you see this article about abolishing prisons. And lest you think this is a joke, I would encourage you to Google this when you have a little time. And as I studied it a little more, what I realized was that in place of prisons, such concepts as social contracts were advocated, as well as community resolutions and restorative justice. Now, we know that every concept can be a part of the overall toolkit, but I myself cannot envision a world without prisons. Can you? So let's run the numbers. To really have a successful dialogue in this area, we really have to understand what the basic facts are. So when we talk about the total cost of incarceration in our country, it's approximately $81 billion a year. This includes prisons, jails, parole, and probation. And let's talk about the number of people the system impacts. As of 2016, 2.2 million are actually incarcerated. And 3 times that number, 6.6, are some part of the criminal justice enterprise, normally a part of the probation and parole system around the country. But it begs the question of when is incarceration appropriate and when would other sanctions be more effective as part of a deterrent strategy and promoting public safety? And I'm still learning how to use this clicker, Oliver. So it's a very fancy looking clicker, by the way. So how do we rank internationally? Well, we actually rank number 1. Although we've lagged in the educational rankings and life expectancy, we're actually number 1 in the number of people that we lock up. And so it requires us to be smart. We lock up 25% of the world's prisoners. We're number 1 per capita in incarceration in the entire world, which translates to 655 people confined for every 100,000 residents. So let's talk about breakdown by offense, because this really starts to drill down into some of the helpful data. So if you, like me, believes the number 1 reason we have a criminal justice system is to protect us one from the other, right? Think about a state of nature. And so we have a criminal courts, a criminal justice system for public safety. And so at the federal level, we see literally half of the confinement, the percentage of confinements at the federal level is almost 50% for drug offenses. At the state level, that's 15%. A couple things I wanted to highlight. At the federal level, violent crimes are about 8% of the total in the federal court system. Now, it gets better at the state system. For violent offenses, 55% of the total. So state prisons are focusing on protecting the public, making sure that you're not harmed by your neighbor or somebody who happens to drive down the road, your street, and decide that they would like to harm you. This chart is also revealing. It shows from 1960 to 2013, it's a little bit out of date, that the violent crime rates in this country have actually fallen some. And when we think in terms of murder and some of your most violent offenses. But what's interesting is that the imprisonment rate has continued to climb and recently has leveled off and then fallen a tad. Now, some of what I do today, since I'm no longer a public official, is I'd like to get underneath everyone's skin just a moment, just a little bit. I want to provoke everybody just a little bit to try to get everyone to really think about this issue from a number of different perspectives. So if you wanted to destroy a legal system, what would you do? Well, you'd make the rules so ambiguous, confusing, and extensive that virtually every entity, every person, is in a perpetual state of noncompliance. Does anybody here actually know every law that we have in this state? Every ordinance? Absolutely not. And, as one of the numerous attorneys in the room, we understand that we are heading to a world of what? Greater and greater specialization. Why? Because it's impossible for an attorney to master every silo, every area of the law. And that's why this is a conversation that we definitely need to have as a society. I don't think anyone would say we're here yet, right? But how do we take steps to simplify, to really make the idea of a social contract meaningful, where people understand the law, have fair notice, and so can actually comport their actions, their planning, to the constraints of the law? So now a number of rhetorical questions. Have we criminalized business? Well, an article from The Economist talks about how I think we would all agree with the normative proposition that companies should be held accountable. But in the words of The Economist, are there times when it becomes extortion? We've all heard the stories of entire industries being shut down and then reopening in China. What does that do for the American worker, for the American economy? Consider the criminal verdicts imposed on U.S. executives in many cases. So it's certainly some thoughts that we need to have about how we hold business accountable in a way, but also allows us to be a meaningful participant in the global economy. What about politics? Have we criminalized politics to some degree? The Ted Stevens case is a real interesting one because a federal judge actually dug deep after the fact and realized that prosecutors had broken multiple rules in the investigation and prosecution of Ted Stevens. But this does not stand alone. And many of us would say, what's happened to civility in our society? What's happened to professionalism? And we know in at least a few cases what's happened to good faith prosecutions. So add to Ted Stevens, former Virginia Governor Bob McDonnell, former Alabama Governor Don Siegelman. According to an article by Josh Stilts, prior to the Supreme Court's ruling in Skilling, the honest services provision, which I referred to earlier, was broadly enforced. And I think all would agree, at times in a very amorphous way. And political officials weren't exactly sure where the lines would be drawn. And I remember when I was Chief Justice talking to several Chief Justices who said they had stopped going to educational programs like this and with legal organizations for fear that someone might take issue with a free lunch, even when there was an educational program attached to it. And I don't think that's a place we want to get as a society, where everybody is hiding in their silos for fear of what happens if they come out of this silo and actually meaningfully engage with other stakeholders. So let's talk about proportionality for a moment. And again, I intend no criticism of the judge in this case, in either case. It's just really a more general concept of where are we in this situation. So we have a mother that murders an 11-month-old and receives 7 years in prison. So what is the value of human life in our society? So then we have bank and tax fraud, where we have federal sentencing guidelines that when you get a sentence, you're going to serve it. And so here you have a bank insider case, and all would agree that white-collar crime is an important issue that needs to be addressed in our country. But we see the white-collar crime sentence twice the sentence for killing another human being. Just really ought to make us think about, are we getting the balance right in how we set up our sentencing schemes? Maybe this is the ultimate example. The lemonade stand. I guess I should go ahead and confess that I'm guilty here. As a child, I operated a lemonade stand. I didn't have a business license. The stand had not been inspected, right? And so you need to know that 3 girls in Georgia were busted by their local police chief for running an illegal lemonade stand. When they were asked why they did it, they said, well, we were simply trying to save up money for water park tickets. In Oregon, a lemonade stand was shut down. In this case, it was a 7-year-old girl, because Portland authorities said the girl did not have a business license and her stand had not been inspected. And last but not least, the parents of kids in Maryland were slapped with a $500 fine for allowing their children to operate a lemonade stand. So again, I'm just trying to get us to think outside the box. Are we where we want to be in terms of the degree of criminalization and regulatory overreach in our society? So what happens when discretion imperils uniform enforcement? We had a district attorney here earlier, and since we have 100 counties, we know we don't quite have 100 DAs. They're by prosecutorial district. But when you have DAs that go down different pathways, where does that leave us in terms of uniform justice? And so in one county, the district attorney has stopped accepting court referrals for school-based incidents, with rare exceptions for serious crimes, closed 20% of the homicide cases, and expanded the use of restorative justice. And so the question really is, we know that prosecutorial discretion is an integral part of our criminal justice system, but we also know another important characteristic or quality is uniformity of application and uniformity of outcomes. And this really guided us and raised the age, because one thing that loomed large is that in 88 counties, young people did not have raised the age. But in 12 counties, local justice systems were already operating a de facto raise the age program. So if you were a young person that was lucky enough to be in one of the 12 counties, well, I guess you could take advantage of that program. But young people in the other 88 were unable to do so. One thing we do know is that unchecked discretion holds great potential for injustice. I always like Ken Davis's quote, and so I'll read it. Where discretionary power is exercised, it ought to be confined, structured, and checked in order to achieve the greatest amount of discretionary justice and the least amount of discretionary injustice. Unconfined, unstructured, and unchecked discretion holds great potential for injustice. So what are our primary goals? Well, first we know that the criminal law deprives an individual of life, liberty, or property. So why do we allow this? Well, I think we first understand that the community, as a group, decides on matters that are so unacceptable that there has to be a criminal sanction attached to it. And so we consider this the moral condemnation of the community. We also want to deter conduct, to preserve order and protect the public. I think Professor Henry Hart said it well. We have to have a formal and solemn pronouncement of the moral condemnation of the community. And those are the matters that should be a part of the criminal justice system. So we know that it's a delicate balance. So if you hear one come forward and say, I have all the answers on this or another, be a little bit suspicious of that declaration, because the reality is this is an area where it is difficult at times to strike the balance. We clearly have the interest of the public, if you view it here in this triangle, in safety, public safety, safety of the community. We also have constitutional burdens that are imposed on the state to make it hard to successfully prosecute and obtain a conviction in a criminal case. And then finally, we have the liberty interest of the individual. And we'll talk a little bit more about that here as we move through the slides. So where does undercriminalization leave us? Well, undercriminalization fails to protect the public from wrongdoers, fails to deter individuals from public mischief or the destruction of the order of peace of society. And that actually goes back to Blackstone. On the other hand, where we have overcriminalization, we still protect the public, right? At least in a sense, but we fail to protect individuals from the state. Oftentimes we convert innocent citizens into wrongdoers because they are not even aware of the standards that they'll be held accountable to. And finally, it erodes trust. If you overcriminalize and the public no longer understands what's off limits, it has a chilling impact on liberty, has a chilling impact on formation of for-profit companies, nonprofit initiatives, a lot of the good that comes out of society where people know that it's okay to move forward on something. So how do we achieve balance? I would advocate that we do so by returning to first principles, the principles that made our legal system and our criminal justice system the gold standard, the envy of the world. In 2008, I was at the World Justice Forum in Geneva, and it was really interesting because we had 600 rule of law delegates there from around the globe, and on the last day, which happened to be July 5, a delegate, and this is prior to Arab Spring, a delegate from Egypt stood up and he said, I know I'm out of order, but I rise to commend the Americans for putting together the gold standard in what a legal system should be. And by the time he was done talking, everybody had risen to give the Americans a standing ovation, including the Europeans, which is hard to do. And so it was a fun day to see that the generations that built a system that was fair, not perfect, but a system that worked, yes, most of the time, was actually recognized as such in the international community. So let's first talk about notice, these first principles. Notice has to be fair notice. It's the notice that provides to a person of ordinary intelligence notice of what's prohibited. That's critical. And what about legislative intentionality? I know we've already talked about this a little bit today. But legislative intentionality requires constant attention to the creation and maintenance of the set of crimes. It ensures against creation of crimes by default, or perhaps as a knee-jerk reaction to a newspaper story, right? And it also requires not allowing outdated crimes to remain on the books without contemporary justification. As to culpability, many of us that did go to law school, we learned about strict liability crimes. And I would say that every time I see a strict liability crime, I'm thinking, boy, I hope the people in the zone of danger here, the zone of interest, have good lawyers, because it's going to take a lot of work when you take away culpability from how our crimes operate. So when we speak of culpability, let's be clear what level of culpability is required under the statute, and be sure this level actually equals wrongdoing, the moral condemnation of the community. So let's talk a little bit more about notice. Madison said in Federalist 62 there were two concepts that we had to focus on. That is the volume of the laws and also the coherence of the laws. And unless we had laws that were not too voluminous and not incoherent, we would have a problem in the operation of our criminal justice system and our set of criminal laws. What did Blackstone have to say? What's interesting is he actually used an illustration from the Roman Empire, Caligula, who apparently liked to make sure that laws were written in a very small character, and then he hung them up on high pillars to make sure the people were ensnared. So I think he represents the opposite of what we're trying to do here. And obviously, we want to make sure that the law can be read and understood by a person of ordinary intelligence, and also that laws are not designed to ensnare or trap, but rather to provide fair notice. And not surprisingly, the United States Supreme Court has weighed in here, and we know that vague laws offend several important considerations, several important values. The void for vagueness doctrine is meant to promote clarity, fair notice, and explicit standards in the operation of our justice system. Now listen to this sentence, and it kind of harkens back to the Ken Davis quote. And here I'm quoting the court in Granite versus City of Rockford, a 1972 case. A vague law impermissibly delegates basic policy matters to police, judges, and juries for resolution on an ad hoc and subjective basis with the attendant dangers of arbitrary and discriminatory application. As a general principle, the more vague your set of laws, the less clarity that is provided through them, the more you're going to see bias in how those laws are applied, discriminatory application, and oftentimes arbitrary enforcement. I listened with great interest at the second panel this morning when they talked about laws that have been passed in recent years that local officials have not even been aware of and have not carried out in the community. Does that mean in only a few communities that those residents only are subject to the laws? And so I think we have a real issue as we see the number of laws in general continuing to increase and increase. So let's apply our general theory of notice to our great state. Well, less voluminous. We have 140 chapters of the state code. I have been a lawyer for 33 years. I have yet to master every dot and tittle just in that wonderful collection. We have automatic criminalization of most local ordinances. So we have 600 additional legislative bodies. Imagine that. We have 601 legislative bodies that are giving us not just tort system principles, right, or something we could be sued about in civil court, but actually criminalization. And last but not least, we have outdated and unconstitutional crimes still on the books. What about clarity? Well, we talk about how it's good to draw clear lines around prohibited conduct, and I hope moving forward that we'll focus on consistent definitions, well-defined principles of culpability, the wrongdoing aspect I spoke of, and of course, ordinary language. So let's talk about legislative intentionality for a moment, because this really does require us to engage in cost-benefit analysis. When we create a law, we're actually creating a new burden on people. Now, what is a new burden? It's a constraint on liberty. It's less that you're able to do on your own, right, in your ordinary affairs. It's also a burden on business and communities and nonprofits and law enforcement, the courts, and undeniably, the state treasury. It takes a lot of money to administer this corpus of laws and to do so fairly, uniformly, and equally. We also have incarceration and the collateral consequences of conviction. Once we have individuals that are convicted, and we'll always have convicted people among us, but if we convict too many, all of a sudden we have a group of people that are no longer able to work in jobs that are legal. What do you think they're going to do? They still have to eat. Many of them will engage in unlawful behavior. So we need periodic reassessment. What worked in 1842 in a much different society than we have today may not work as well now. And also we get back to the ordinance and regulations, where these take on the status of crimes. Should we have a deeper dive to ascertain what should be the scope of authority at the local government level? What should be the possible range of sanctions that are appropriate at the municipal and state and local government level? And are we ensuring that culpability is a part of those ordinance violations? Now, I love this slide because it shows us what computers have done to us. So, I don't know how many people in this room know that 1 out of 7 drivers in our state has a suspended license. I just want to know, how many knew that? Couple, okay. Well, I'm here to tell the rest of you that we have one of the highest rates of suspension that I've heard of, and I went to a conference on this recently at Duke Law School. And so it kind of raises the question of what's going on here. Well, I can tell you what's going on. These are computer-generated notices of suspension. And so when a fine is not paid or someone does not show up for court, that data is entered in a data system, and the computer system itself, I guess our first AI judge, Dean Leonard, the computer itself decides that a driver will lose his or her privileges to operate a motor vehicle. Now, you might say, well, so what? They did something wrong, and they need to be held accountable. Well, I agree. Is that what we're doing through suspending 1 out of 7 drivers? What is the impact of this on North Carolina families? What is the impact of this level of suspension on working class families and individuals who were already struggling to make ends meet for their family, to do things right, to work as a painter or a brick mason or a plumber? And all of a sudden, the very tool they had to go and do their work, their automobile, is taken away. And you say, wait a minute, what about mass transit? Well, in most parts of our state, that's not a realistic possibility. So you have many individuals, and just so you'll know, 1 out of 7 is over 1 million suspended licenses. So when you have this many suspensions, it creates the Hobson's choice for these individuals of what? Driving anyway, and what happens when you drive without a license? The penalties get more significant and higher. So that's one choice, right? And that'd be the right choice. But oftentimes, well, that would not be the right choice. Got that backwards. Shouldn't drive without a license. I better catch that one. That might make under the dome, even though I'm now, just up here as a lunch speaker. But so what's the other option? Not driving at all. So what do you think an employer is going to do if the worker can't come to work, right? And the worker's wife is home in bed sick. He's been working to try to pay for those Duke healthcare bills, and all of a sudden, they're both in a pickle, right? She has a medical ailment. He can't go to work. So this is a real issue, and it doesn't have to be like this. You can have a judge assess whether that defendant, how much that defendant can pay. Because see, if you make the fine proportionate to what somebody can pay, the research shows they actually pay it. So if you're making $400, $500 every week or two, and you go in and you require that defendant to put down the expenses and figure out what could be paid, almost like the child support guidelines, you'll get a whole lot better collection rate. On the other hand, if you just slap the standard fee down, oftentimes, if that fee is more than you make your net pay for the month, you just give up. You figure there's no way to do it. And that's what leads to a lot of these situations. So getting back to culpability, I would maintain that individuals should not be held criminally liable with all its intended consequences, confinement, probation and parole, numerous disabilities that arise from a conviction on your record for unintentional conduct. Yet many of our statutes fail to define the level of culpability required for conviction. And so we need a good example. So here we go. I can't tell you how often I've had a bird bath in my yard. But yet we have local ordinances that make it a Class 3 misdemeanor to have a potential breeding ground for mosquitoes on your property. So if I'm your lawyer, I would say, unless you have the opportunity, unless every 48 hours or so, going back to my scientific knowledge of how quickly it takes mosquitoes to develop, but get the bird feeder out of your yard, because you are in violation of most local ordinances on this topic. But we do have a ray of hope, and we have a General Assembly that is very supportive of this work, and many in this room, the great work you're doing to move this project forward. Yet, and I find this very interesting, and if Rose is still here, I'm not taking a slap at local government in saying this. Local government is busy too. But when this statute was first passed in 2018, when I was still Chief Justice and we were working with Becky Gray and others on this issue, it really wasn't caught by as many local governments as should be. And doesn't that go back to our central theme? That the body of law is so extensive that not even local government can fully keep up with it. And I think that's telling, is it not? And so local governments didn't do their work under the statute soon enough. So, as we often do in government, we had a relief act. So Senate Bill 584, about a year later, did what? It extended the time for local governments to report ordinances that have a criminal penalty or criminal sanction. So there we go. Even our own government could not keep track of the changes in the laws and perform the duties that it was required to do under the law. So at the end of the day, we know that wherever law ends, tyranny begins. And if we do not have a body of laws that provide fair notice, if we do not have legislative intentionality to ensure that we have clarity, laws that can be understood by a person of ordinary intelligence, and if we don't ground our laws with the concept of culpability, that we know it's easy for the law to end and for tyranny to begin. Thank you so much for allowing me to be with you today.
I think we do have some questions if you want to be peppered with them here.
Oh, I'm fine. Questions are good. Chris?
So I was struck by your slides about discretion and where discretion can lead. And it got me thinking about the balance in the justice system, the amount of power prosecution has and discretion prosecution has, and power and discretion law enforcement have, and even the victim associations are very, very respected and have influence. It seems there's been a lot of examples where the defense bar does not have a voice that is respected or heard. And so how much of this process, it seems like defense bar would have a lot of input, and there's an imbalance in who's considered a stakeholder in the system. So when we have, like, the Durham District Attorney, I mean, if the saying is that the wheels of justice turn slowly, the wheels of justice changing direction is impossible. So unless you have people who are willing to step out and use their discretion to try to make change, when the people who might have the most input, like the defense bar, are excluded from the process, I mean, isn't discretion the exercise of that discretion necessary, or bringing the other stakeholders into the process necessary for change?
Well, that's a great question. And what we realize at the end of the day is there's really a constellation of values. And if we get them in the right balance, it leads to pretty good outcomes. So we have discretion on the one hand, and then we also have uniformity of outcome. You know, same facts, same punishment on a statewide level. You know, and we're talking about the 9th largest state and over 10 million people. So, I mean, it's a lot of considerations. But what I would come back to is not that discretion is inherently bad, but that we need standards for the exercise of it. And really, the point I'd like to make is the legislative intentionality. Where discretion is exercised, let's make sure we have clear standards, not only for the citizen, but for the government decision maker that has to look at those facts and make a sound decision. And so, you know, I think it's a good point at the end of the day. And I'm in no way, you know, criticizing any DA. What I am saying is you also have to consider the value to the extent you can humanly achieve it of having the same outcomes for the same facts. And so, you know, where you have a number of different district attorneys, if you have some that go about their work exercising discretion in a very different way, you know, is it going to come down to which county you happen to be arrested in? I hope not.
Yeah, I understand the importance of uniformity, but if you can't make change, what's more important, uniformity or uniform injustice?
Well, I guess my response to that is I think the change should begin with the legislative branch. In other words, let's talk to the legislature about, you know, getting rid of outdated laws, making sure our statutes promote the values that we've talked about at the conference. And then once we get the playbook there, then I think we then talk about discretion. So the problem I have with just discretion operated upon the current set of rules in different ways in different places, if that gets too far afield, all of a sudden we have citizens having outcomes that are not uniform at all. And that's why, as a state, we eliminated all of the local courts and put together a uniform system based upon the work of the Bell Commission, starting in the late 50s. The thought was that we would have someone who would get caught for speeding in Asheville, Wilmington, and Winston-Salem and have such a different outcome that we thought, wait a minute, this can't be. We need a unified system. So if you look at the history of criminal justice systems and legal systems generally, what you tend to see is you reach a point of uniformity, then it immediately starts going out of uniformity again, right? And then you have to take things to try to bring it back to be more uniform. So I think we've faced that as a state before, and I'm not sure we're not at a point again where we need to take a holistic view of the set of laws, and that's why I'm so delighted what Cato is facilitating for us here in North Carolina. Any other questions? Oh, I'm sorry, Becky, I didn't see you.
Chief Justice, you were so instrumental in the reforms and the changes to raise the age effort, and I know that came out of the special study commission that you had spearheaded. Can you just talk a little bit about the successes that you had with that, but also kind of the roadblocks that you had, and applying what you learned from that effort? Could you talk a little bit about efforts moving forward with criminal law reform?
Certainly. Well, I think that one of the areas that everybody felt good about, we've already talked about, and that is that, and I really want to acknowledge Professor Jessie Smith. I gave this professor a Friend of the Court award for her amazing work on this, because we all like to talk about what's going on with our young people, but Professor Smith actually went in and looked at the data, and what we learned is that 97% of what our 16 and 17-year-olds were getting in trouble for was not serious crime. And so we had probation officers and prosecutors' offices and defense lawyers all struggling to defend kids for very minor situations, and in many instances taking away time for those serious offenses where a teacher had been assaulted or a fellow student. And John Locke, Becky, you were right there on that innovation. Now, lest you think that we were doing something that was unusual, guess what? 49 other states had already made that change. So we were late to the party when it came to raise the age. And So as to the commission as a whole, one area where I was very frustrated, but we really didn't know what to do, is rotation of our Superior Court judges is constitutionally required, and among others, I see a lot of salutary aspects of that, but because of rotation, we had a harder time keeping one case with one judge. So of course we had the business court, we had Rule 2.1 designations, extraordinary cases, and in those instances we mirrored the federal model of assignment to a single judge where that judge could monitor pretrial, trial, and any post-judgment aspects. We've so far been a little bit frustrated in our ability to try to get one judge to take hold of a case, to put staff in place to help that judge to keep the case moving along. The Chief Justice of Utah thought he was probably going to be impeached when he put this standard in his state. He thought the lawyers would just find it totally unacceptable. Within a year, they were sending him letters talking about how well the system worked. Because you see, lawyers were getting letters from the clerk's office reminding them of the next step. And like all of us, lawyers are busy, have a lot of cases. And to have a system where you have protocols in place, pathways, I guess you could say, very straightforward cases, kind of run-of-the-mill cases, and then very complex cases could have higher degrees of staff intervention. So that's a place we've so far been unable to get in our state, but I hope we can do so over time. One matter of of unfinished business is why we're here today. And I remember the two of us having a conversation about trying to make headway in this area because of, frankly, we were not doing for a state that has always been a leader. I'm so proud to be a North Carolinian. This was an area where we had so many other things we were trying to say grace over, sometimes just trying to get the budget done. And we had not had time to really take a look at doing an overhaul of our criminal laws in the state, and so the set of criminal laws. So that's one area where we didn't make much progress, I'm afraid to say. And I hope that progress can take place now. Thank you very much.
All right, well, now that we've wrapped up lunch, we're going to take about another 15-minute break. And I know lunch was exhausting. We'll take a 15-minute break, and we'll convene the next panel at the end of that break.